You're sitting at a red light, tail light out, nothing serious. Blue lights hit your mirror and your stomach drops. The officer walks up to your window and says something you've heard 1,000 times in videos but never live. I smell alcohol on your breath. In that instant, everything changes. Not in the courtroom, not at the precinct, right there at that window in the next 10 seconds. Your entire case, guilty or innocent, gets decided by what you say and don't say while his body camera is running. This is about the 4 sentences that law enforcement desperately does not want you to know. This is about the system they built to trap you and the legal architecture that makes it work. If you drive. If you have ever taken a drink and gotten in a car. If you have ever wondered what you should actually say in that moment, this video is required viewing. Subscribe right now because what you learn in the next 25 minutes could be the difference between a conviction and walking free. I'm going to walk you through exactly what's happening at that window from the officer's perspective, and then I'm going to hand you your side of the conversation word for word. I spent years watching these stops go wrong, not in the legal discovery phase, not when the evidence got suppressed at the window in the first exchange. The same mistake happens over and over, and it's not what most people think. The mistake is thinking you're having a conversation when you're actually being questioned. The mistake is believing that cooperation looks the same as innocence. The mistake is not understanding that the officer is not asking questions to find out if you're guilty. He already assumes that. He's asking questions to build a file. Every number you give him goes into the report. Every timeline you mention becomes part of his narrative. And by the time you realize what happened, by the time you think about calling a lawyer, you've already lost. The system is built on a fundamental premise that most people don't understand. At a traffic stop, you have fewer rights than you think. The Supreme Court established this in 1984 with a case called Burkimer v. McCarty. The ruling was clean and brutal. A routine traffic stop is not custody. No Miranda warning is coming. Everything you say at that window is usable in court. Your silence doesn't protect you. Your sense that this is just a routine check means nothing. Legally, you're not in custody, so the constitutional protections you think exist simply don't. But there's a second half to that ruling that almost nobody covers. And getting this part wrong is worse than saying nothing at all. Some things at that stop are mandatory and some are not. You must provide license, registration, and insurance. Under Pennsylvania v. Mims from 1977, the officer can order you out of the vehicle and you must comply. Refusing either is its own criminal charge. But here's what matters. The things that feel optional to you, answering questions about where you've been, how much you've had to drink, whether you'll take a sobriety test, whether he can search your vehicle, those things actually are optional. The problem is that most drivers don't know the difference. Most drivers think cooperation is the same as innocence. Most drivers think that saying, "I've had one drink," sounds better than saying nothing. And by the time the body camera footage is playing in front of a jury, it's too late. The officer is playing a game where he already knows the ending. He's using language that sounds conversational, but is actually legal. When he says, "I smell alcohol on your breath," he's not making an observation. He's triggering the legal justification to keep you there, to order you out of the car, and to start collecting evidence. He doesn't actually have to smell anything, he just has to say it. And the moment those words are on the audio recording, he has documented probable cause. He's listening for one specific thing in your response, a number and a timeline. 1 beer 2 hours ago. That's a quantity and a clock, and both go into the official report in your own words. From that point forward, the prosecution doesn't have to prove you were drinking. You've already done it for them. They use your own words. They play the body camera, and the jury hears you saying it. This is where the game is won and lost, not later, not in the courtroom. Right there, right then. Because once you give him a number, the file exists. Once you give him a timeline, he has a narrative. The arrest report practically writes itself. Here's what the law actually protects and what it doesn't. The Supreme Court decision that changes everything here is Berg House v. Tomkins from 2010. The ruling stated something critical that almost no one understands. Staying silent is not enough. Just sitting there, not saying anything, doesn't invoke your right to an attorney. Silence by itself doesn't protect you. Your silence can be used against you later. The jury can be told that you didn't respond, that you seemed evasive, that you wouldn't cooperate. But here's the part that saves you. The moment you speak the invocation out loud, the moment you say specific words, requesting a lawyer, And that protection activates. The words have to be explicit. The officer has to hear you say them, and the protection has to be clear and unambiguous. Once you say it, if the officer continues to question you, any statements you make after that point are legally compromised. But, and this is critical, the protection collapses the second you re-engage. Most drivers deliver the line perfectly. They say exactly what they should say, and then they add one more thing, just one more sentence to soften it, to make it sound less rude, to seem more cooperative. That one extra sentence is the file. That one word is the conviction. Because the moment you keep talking, you've waived the protection, you've signaled that you're willing to discuss it. You've opened the door and he walks right through. The first sentence you're going to hear from an officer during a DUI stop is going to sound almost friendly. It's scripted to sound that way. He'll say, "Have you been drinking tonight?" And your instinct, your human instinct, is going to be to answer. You're going to want to say just one beer, or I had wine with dinner, or nothing that matters. You're going to want to split the difference to seem cooperative, to show that you have nothing to hide. It feels like honesty. It reads as an admission. Here's exactly what you say instead. "Officer, I'm not going to answer questions and I'd like a lawyer." Word for word, say it calmly, say it once, then stop talking. Don't elaborate, don't soften it, don't add anything. The silence that follows isn't awkward, it's your constitutional protection activating. This works because of that Berg House ruling. You've invoked your right to counsel explicitly. The words are on the recording, but the second you keep talking, the second you say, "But I only had one beer," or "I'm really fine though," you've destroyed your protection. The officer will sit in silence too. He'll stare at you. He'll make it uncomfortable because that's the job. But if you stay silent after invoking, the legally protected zone exists. If you re-engage, it doesn't. The second sentence comes after he orders you out of the vehicle. This part is not optional. You must exit. Under Pennsylvania v. MIMs, refusing to get out of the car is its own charge. But what comes next is optional. And this is where drivers get it catastrophically wrong. He's going to say something like, "I just need you to do a few quick tests so we can clear this up." Those tests, the walk and turn, the one-leg stand, the horizontal gaze nystagmus, they are voluntary. They are not required. And almost every driver fails them because they don't understand what a pass actually means. These aren't pass-fail tests. They're scored on clues. Every wobble gets noted. Every early start gets written down. Every time your arm goes up for balance, it goes in the file as a sign of impairment. Your fatigue produces clues. Your age produces clues. Being terrified on the shoulder of a highway at night with blue lights in your eyes and an officer giving you instructions you've never practiced produces clues. The system is designed so that you fail no matter what you do. Here's what you say, "Officer, I'm not going to perform any field sobriety tests." Word for word. Don't argue. Don't explain. Don't say you'd be happy to, but you're nervous. Don't say you have bad knees or a bad back or that you're tired. Just say the sentence and stop. The reason this works is counterintuitive, and most legal commentary gets it badly wrong. People will tell you that the Fifth Amendment protects you here. It doesn't. Pennsylvania v. Muniz from 9/1990 drew the line clearly. How you sound and how you move, your physical behavior and appearance is physical evidence. It's not testimony. The Fifth Amendment protects the content of what you say. It protects speech. It doesn't protect your body, your movements, your appearance, or your demeanor. But here's what does protect you. In most states, these field tests are voluntary. That's it. The protection is that they're optional, not constitutional. And I'll be direct with you because a lot of channels won't be. In many states, a prosecutor can tell the jury that you refuse the tests. So you're trading a certain stack of clues, 6 observations of impairment on video, permanently for an argument you can actually make in court. That's the calculus. 6 documented clues versus the ability to say under cross-examination that the tests were not administered properly, that the conditions were not suitable, that there's no scientific basis for the scoring. One path leaves you with evidence, the other leaves you with a defense. Subscribe right now if this is landing, because this is the part where the system really starts to show, and this is where law enforcement's game becomes visible. Most channels are not going to tell you that refusing field sobriety tests can be mentioned to a jury. They're going to tell you it's a constitutional right to refuse. It's not. It's a practical choice. The choice is between certain evidence and a fighting chance. Choose the fighting chance. The third sentence is where the system becomes criminal. The officer pulls out a small handheld device. It looks like a breathalyzer. It's designed to look like it matters for your case, and it is absolutely not what most people think it is. He's going to say something like, just blow into this so we can clear this up and get you on your way. And that second part is key. He's framing this as an exit. It's not an exit. That handheld device and the machine at the police station operate under completely different laws with completely different legal consequences. Almost nobody knows this. It's the most expensive gap in DUI defense. Here's exactly what you say. At the roadside only, Officer, I'm decoding the preliminary breath test. Word for word, nothing else. The reason this works is that for most standard drivers on a regular license, the roadside handheld test is voluntary. Its results don't prove your blood alcohol level. It doesn't establish intoxication. In many states, it can't even be used as evidence in court. Its only legal function is to generate a number, and that number one number on a small screen is often the difference between a maybe and an arrest. He has probable cause based on observation. The handheld gives him permission to arrest. The arrest gives him the ability to demand the station test. And the station test is where the real consequences begin. The station test is not voluntary. Every state has implied consent laws. Once you're arrested, you're required to submit to a chemical test, breath, blood, or urine. Refuse at the station and your license is suspended, often for a longer period than an actual conviction would cost you. But it gets worse. A 2016 Supreme Court case called Birfield v. North Dakota changed the entire landscape. The court held that states can criminalize refusal of a warrantless breath test after arrest. They can make the refusal itself a crime. That's a separate charge. That's additional prison time. That's on top of the DUI conviction. There are only two exceptions to this: commercial drivers and anyone under 21. For those groups, the roadside test rules are tighter, but for everyone else, this is the decision point. At the roadside, the handheld is optional. At the station, the chemical test is not. So that distinction is everything. That distinction is the difference between being able to fight your case and being locked into it. Because here's the reality. The station test uses machines with calibration requirements. It uses procedures that can be challenged. A defense attorney can argue improper administration, lack of training, equipment failure. None of that matters. If you've already blown into the handheld and given him a number, that number becomes the foundation of his entire case. The handheld number is often the headline, and it's what gets reported. It's what the jury remembers. The fourth and final sentence comes near the end of the stop. It sounds casual. It sounds like a request between friends. The officer says something like, "You don't mind if I take a quick look in the vehicle?" Right. That word at the end, right, is doing all the work. It's designed so that saying nothing sounds like saying yes. It's a question structured to trap silence into compliance. Here's exactly what you say. "Officer, I do not consent to any search of my vehicle or my person." Say it clearly. Say it loud enough for the body camera microphone to catch it. This works because of a Supreme Court case called Schneckloff v. Bamonte from 1973. Consent has to be voluntary. But the court held something that almost no one explains properly. Police do not have to inform you that you have the right to refuse. They can ask in a way that doesn't sound like a question at all. They can frame it as a favor or a formality. In plain English, the law lets them manipulate language. What your refusal does, and this is critical, is it doesn't physically stop the search. The officer searches anyway if he has the authority, but what it does do is force him to articulate that authority on the recording. That's the difference between a search your lawyer can challenge later and one that's locked in by your own consent. Subscribe and stay with us, because this is where the entire system becomes visible. This is where the difference between silence and protection gets revealed. When you refuse consent, you're not stopping anything. You're creating a record, and you're forcing him to justify on audio what he's going to do anyway. That record, that moment where he either cites probable cause or he doesn't, that's what your attorney uses later. And that's what gets played to a jury. That's what determines whether evidence was properly obtained or whether it was planted against you. Consent closes that door permanently. You don't just lose the argument about whether the search was legal. You concede it. You admit it was voluntary. You surrender the entire line of defense. Let me give you the reality. Sober night, wrong way. 11 at night, 1 glass of wine with dinner, 2 hours ago, pulled over for a broken taillight. Officer asks if you've been drinking and you say 1 glass. Officer writes down the admission, the time, your own words. He notes slurred speech even though you weren't slurring. Officer orders you out. You take the field sobriety tests and you wobble. Because it's cold, you're nervous. You've never done this before, you're under pressure. Wobble gets documented as impairment. Officer produces the handheld, you blow a .04 under the legal limit. But he now has a number and 6 clues of impairment documented on video. Officer asks about the trunk. You want to seem cooperative, so you say, sure. He finds an open bottle from a party last month. A friend's bottle left behind. 2 charges now. DUI in possession of an open container. Same wine, same taillight, different night. Same night, same wine. Right way. You give the 4 sentences, he orders you out. You get out, because that's required. No admission about drinking, no clues documented from field sobriety tests because you didn't take them, no number in the file from the handheld because you declined, no search of the vehicle because you refused consent, no open bottle evidence because you refused to allow him inside. Same amount of wine in your system, same taillight burned out, completely different outcome, no charges, no conviction, no suspended license. The only difference is what you said at that window in the first 10 seconds. Here's what to memorize because it matters. When he asks if you've been drinking, you say you're not answering questions and you want a lawyer. When he asks for tests, you decline. When he pulls out the handheld, you decline the preliminary breath test. When he asks to search, you do not consent. 4 sentences, 4 moments, 4 opportunities to protect yourself. And the officer least wants to hear sentence 3. Everything else takes away a description, removes observations of impairment from the record. That one takes away a number. And a number is the only thing in a prosecution file that a prosecutor never has to explain. The handheld reading is presented as fact. It doesn't require interpretation. It doesn't require the officer to testify about procedures or training or calibration. It's a number. Prosecutors love it. Officers offer it as a favor. Defense attorneys dread it. The moment that number exists, the case becomes harder. The moment you've declined it, the case becomes winnable. This is general information about how these stops work, not legal advice for your specific case, and the details shift state to state significantly. The Supreme Court rulings I've cited set the floor for rights across the country, but your state may have additional protections. Your state may have stricter rules about what officers can do. A lawyer where you live is worth the call, worth the money, worth having the conversation before you need it. Not after you've been arrested, not after the body camera footage is already filmed, before. Because once you're in the system, once the file exists, once the number is recorded, your options become limited. Your leverage disappears. Your case becomes what the officer decided to make it in those first 10 seconds at the window. This is the moment where most people decide whether they're going to fight or accept. This is the moment where you find out if you actually have rights or if you just have the hope of them. The system does not want you to know these sentences. Law enforcement does not want you calm and informed at the window. They want you scared and compliant. They want you thinking cooperation looks like innocence. They want you believing your silence hurts you. They want you giving them numbers and timelines and admissions because that's what closes the case. That's what makes the paperwork easy. That's what gets them home on time. Your freedom is not the priority. Efficiency is. And the system is built to prioritize their efficiency over your rights every single time. These 4 sentences are your resistance to that system. They're your refusal to participate in your own conviction. They're the words that make you dangerous to a prosecutorial system that depends on drivers making mistakes at the window. Say them calmly. Say them once, then trust that saying nothing, after you've said what matters, is the strongest position you can take.